Well, hello, and thank you very much for joining me in another of my tax discussions. I've got today, I'm Andrew Hubbard, who is currently the editor-in-chief of Taxation magazine, one of the leading journals on taxation in the UK. Andrew, thank you very much for joining me. I was wondering if you could just explain a bit about your career to date.
Yes, thank you, Keith. It's really good to be joining you, having this conversation. My career today, I like to think, followed the typical route in that I studied music at university and did a PhD, and then spent a year as a house husband, and then finally had to decide what to do with the rest of my life. And I went along to a university careers advisor who clearly took one look at me and thought, what on earth have we got here? And said, why don't you think about the civil service? So I said, okay, because I was a very obedient young man by that time, and they were recruiting in the revenue. So I went along to the revenue office, talked to them, and before long, I went through the civil service selection board and had my first experience of work as an inspector of taxes. I always say to people that if they've been looking for public health officials, I might have ended up as a rat catcher or something. And you can make the comparison if you like. And I think that was my first experience of tax. I don't think I'd ever paid any before then, so quite an eye-opener. I was in the revenue for a few years, really enjoyed it, had a fantastic basic training in the way the tax system works, which has stuck with me all through my career. Like many people, joined into the private sector for a number of firms. Eventually I became a partner in BDO, then had many interesting years in Tenon, which was a very exciting place to be. Ultimately, it didn't quite work out, but it had huge potentials, and it was a really exciting time to be there. And then through a number of other iterations, finally ended up at Taxation magazine, where I joined for 2 days as editor-in-chief. I think you were on the review panel, weren't you, for that, Keith? So there we go. Thank you for that. And then I was doing that in conjunction with being a partner. And then over the last few years, I've changed the emphasis. So I now write for 4 days a week for LexisNexis. I'm really editor-in-chief of all of the tax publications, so keeping an eye on what's going on in the tax world, and obviously through Taxation, a weekly magazine. I like to think we're representing the pulse of what's going on in the profession, and it's a fascinating thing to be able to do. It's been going on for nearly, over 90 years now. I'm hoping to hang on for the centenary. And some of the issues that we're no doubt discussing were discussed 100 years ago in taxation, the balance between the revenue and the state, how far could the revenue go back, all of those sorts of things. And I don't know about you, but I find it fascinating to see, what comes around goes around. So,
how often do you delve into old magazines?
When I was actually working in London, before I was stuck at home, they have the complete set of taxation magazines at the office, and I used to look at those. I do have quite a nice tax library of my own that I've built up over the number of years. Been trying to make sure I've got all the annotated finance acts going back to the first publication from Butterworth's in 1939, and some of the old acts, and it's quite interesting just to see. I've got some old tax returns and the like, so it's quite fun to have that. So you can't see everything in the library here, but there's quite a lot here, so if you ever come you can have a little tour. But there we go. Yeah,
I look forward to not only the opportunity but the fact that we'll be able to have
tours. It will be great, won't it? Yes, I'm hoping maybe next month to go to London for the first time since March of the previous year.
We shall see. Now, this discussion was very much prompted by the Supreme Court's decision in the Tooth case in the middle of May, and you wrote an article in Taxation very shortly after the Supreme Court's decision.
Yeah.
And the heading is "Putting an End to Staleness."
Yeah.
And I think you can infer it from the opening paragraph, but you become more clearer later on in the article. You probably were not a fan of the concept of staleness as far as the definition of tax, whether a discovery was still a discovery or not. Would that be a fair?
Yeah, I think it would be a fair thing. I mean, obviously, it's a very powerful, or was a very powerful argument to use in individual client cases, and the situation arisen. That would have been something I would want to have argued. We can talk about that. But as a matter of public policy, I I felt quite uncomfortable with it because it was something that appeared to develop almost out of nowhere. And the question for me was, yes, maybe it is right that the revenue have to do something within a time limit of discovering something, but what should that be? And given that we have the assessing time limits, where is this other call to action, if you like, that the revenue have to do? Where does that come from? And is that right? Now, had Parliament said, okay, you must revenue make an assessment within X months or years of discovery, that would have been fine. But this sort of just sort of floating out in the ether made me quite uncomfortable. And you obviously have in the VAT world
absolutely
a provision where you say, okay, you've got a time limit, but after the first year, you've got to do certain things within a certain time. And I just felt it was too amorphous. And you got all of those first-tier tribunals where some people were very, very strongly of the view that it didn't exist as a concept.
Yes.
You had others who embraced it very warmly, and I mean, it was right ultimately that the Supreme Court had to make the decision. So I feel that it's right that the Supreme Court reached the decision that it did. I think it then opens the question: what do we do next? Should there be some framework around the revenue acting promptly? I think that's open for discussion.
We'll come to that in a moment. You made a number of points in what you just said. The first is the fact that different courts have come up with very firm views as to whether or not there is a concept of staleness. And I think this is I found this quite fascinating because Patullo was the first case which argued it in full.
Yeah.
And this was in about 2016. And what the upper tribunal said is the requirement for the discovery to be acted upon while it remains fresh appears to me to arise, and I quote, on the natural meaning of section 29(1) itself. Yeah. So what the upper tribunal in Patullo said is it's implicit but clearly implicit in the word discover.
Yes.
Mehrban, which is one of the cases you refer to in your own article, made very much the same point. The word discover connotes an element of newness or freshness. It would be an absurdity to hold otherwise. So yes, there are definitely courts, and I've been in front of judges who've said, what's this staleness concept? But we haven't had to argue it because it was accepted that you had to have this concept. So you have otherwise two judges in particular who've said it is absolutely fundamentally clear that's what the statute says. And then the Supreme Court says the statute is absolutely clear. There is no such concept. And to me, whichever is right, it cannot be right that the meaning is clear if lots of intelligent people are saying it's clear but reaching completely opposite conclusions.
Isn't there a difference though between saying that the discovery means essential newness, and I get that. To be a discovery, there has to be something new. But what's that got to do with assessing time limits? That's the bit I don't get in the argument.
The way I would explain that is, don't worry about assessing time limits. That in many ways is a distraction. Yes, there are assessing time limits, and we know it's 4 years, 6 years, 20 years, depending on the circumstances. The question is, it's your power to assess. To assess, there must be a discovery. And I would you accept?
The
question is, does section 29(1), and when it says there must be a discovery, does it mean if at some point in the past or present an officer discovers, in other words, we can sort of go to the 1912 to 1913 case law, say, well, let's rewrite it. Say, if an officer is of the reasonable belief that A, B, or C has happened, then the officer may issue an assessment. So that could be one interpretation. And if you look at the other statutory provisions dealing with determinations and on closure notices, it's all about what an officer believes. But this provision, and it's of historical, this provision has been there for a very long time.
I've got my 3 Act with me just in case we need.
Thank you. So you're going to cheat on the test I was going to suddenly throw upon you.
Absolutely, yeah.
Is there equivalent wording back in the 1803 Act?
There's certainly reference to what happens if a surveyor discovers in the context of window tax.
So the legislation is over 200 years old. The wording is over 200 years old.
Yeah.
The question is, rather than say, if an officer is of the belief, they actually focus on the word discover.
Yeah.
And therefore it puts section 29 and those similar provisions which deal with discovery in a different category from those provisions which say if an officer determines if officer is of the view.
Yeah.
And therefore the question is, does that extra category have a different, import a different test? And the test could easily be, the assessment can be made only whilst, almost as a consequence of that discovery, not, oh, there was this discovery in the past and based upon some historical event, we are now going to take action. So I could say that, I would be happy to say that the word discover does imply that there is an obligation that if one is going to assess, one does it whilst the discovery is still a discovery rather than ancient knowledge.
Yeah, that's the bit I think I still find difficulty, because once a discovery, you know, if I've discovered something, does the effluxion of time mean I've undiscovered it? And that's the bit that I really struggle with, because if you say, okay, Inspector X or Officer Y has made a discovery,
yes,
and we accept that he has, what turns it then into something that is an undiscovery if he doesn't act?
It's the present time. It's the use of the present tense in section 29(1).
Yeah.
If an officer discovers.
Yeah.
In other words, there's got to be that connection between the discovery and the assessment.
Yeah.
And as a matter of public policy is concerned, I think, well, I would say that it requires officers then to act in an appropriate way. Now, I've always said it doesn't mean discovery on day one, you have to assess within 2 days, 30 days or something.
Yeah.
You have to keep the discovery fresh, effectively act upon it in a professional way. And there's plenty of case law which gives that flexibility of cases where, well, the officer discovered, but the taxpayer was made aware of it. No one pressed the button on the assessment machine because there was no need to, it won't come out to time limits. The parties were in the course of discussing it.
Yeah.
It ensured that the officer didn't sit on this knowledge and hide behind it and then spring it upon a taxpayer years later.
So you would import a high degree of, if you like, urgency on the matter than is given by the normal assessing time limits.
Yes, those time limits are backstop provisions. In other words, suppose you have underpaid your tax and you've discovered that you have underpaid your tax.
Yeah.
And you think, well, actually, the relevant time limit for the revenue to assess doesn't expire until 3 years down the line.
Yeah.
So there's no point me telling them until, let's say, 2.5 years.
Yeah.
That, I suspect, would seem slightly wrong as far as how taxpayers should behave.
Mm-hmm.
Would I be correct? You ought to at least alert the revenue within a reasonable period of time of making your own discovery you've underpaid tax.
I think as a citizen, I would hope that the citizen of the country would be, and as a tax professional, that is also how I would want and how I have operated. It's an interesting question as to where that actually sits in terms of legal obligations within the TMA. And if we are saying, you know, everything is governed by the TME and responsibilities, haven't I, as a taxpayer, if I put in, hypothetically, an incorrect return 3 years ago, and I'm reviewing my papers to do this year's return, and I find that there was a mistake, I don't know, depreciation didn't get added back. What does the TMA actually tell me I've got to do? In fact, it doesn't tell me anything, does it? And it says, once that assessment for all my self-assessments become final, which it will have done, it's inviolate unless the revenue do something about it? So it's an interesting question, which we may want to move on to at some stage. But
absolutely,
I think if we're going to say, what does the TMA actually require of an officer? What does it require of a taxpayer? Then we're getting into very, very deep waters there, I think.
But even if we don't worry about where the obligation comes, I think we're in agreement that a taxpayer who discovers a mistake he or she has made shouldn't sit on that, and within a reasonable period of time act in an appropriate fashion.
Yes.
And I would say that the same would therefore apply to an officer.
Yeah.
Just to give an example, there was a case which you might have come across, WT Banks Co. Farming Limited. It was a case about loans to participators and intercompany loans.
Yes.
And the loan relationship rules. And I feel that the taxpayer has suffered for two reasons. One, not having actually kept a record of what the transactions were at the time, but also through the effluxion of time that 10 years later, it was going to be hard to persuade a tribunal judge that a certain state of affairs was in fact the case. It could have been optimistic argument.
Yeah.
And the difficulty with relying solely on the statutory time limits is that it puts unfairly too much emphasis on a taxpayer to keep the records, which not every taxpayer does have. There's no obligation to keep a record of absolutely everything. It just helps you if you have an argument as to what was your reason for doing X, Y, or Z.
I mean, sorry, Keith, aren't you then strutting a little bit into judicial review territory? And I know I had a conversation with one of my senior colleagues after Tooth about, well, in fact, doesn't the Staleness argument now become a judicial review argument about the reasonableness or unreasonableness of an inspector's or an officer's decision to sit on it, as it were, and that's the forum, and it isn't a Taxes Management Act issue?
That's exactly what the Supreme Court said.
Yeah.
That if the officer has acted in an irrational way, then there would be grounds for judicial review. And where the line is between unreasonable and irrational, that will have to be decided on a case-by-case basis.
Yeah.
But even so, that judicial review implies that even over and above what the TMA says, there are certain public policy rules of law that operate in this field.
Yeah.
So the TMA, whilst it's a comprehensive code, doesn't contain everything.
Yeah. But in that case, why look to a TMA solution and an appeal under the TMA for a solution to the Staleness issue? Isn't what you're saying that you're actually taken outside that framework? So there's no point in looking at what the TMA says because your solution is elsewhere.
Well, I think that all turns on what does the TMA actually say.
Yeah.
If the TMA says, by using the word if an officer, or the words if an officer discovers,
yes,
which is, as I said, a different formulation from what you find anywhere else, then actually it does incorporate within the tribunal's framework that test in precisely the same way that the much more modern VAT legislation puts it down in express terms.
Yeah.
So no one's going to say that you shouldn't be able to argue time limits in the VAT context. And I've actually had it very recently, a case where the revenue caved in on the basis of that 1 year time limit. They had the information, they ignored it. So it's perfectly acceptable as a matter of public policy for the VAT officers to make the assessment within a prompt period of time set as 1 year when it comes to VAT. What I say the TMA does is incorporates exactly the same imposition on officers, but doesn't do so with an explicit 1 year timetable. It's just within a reasonable period. I would say is implicit in the word discover. And that then gives the tribunals that flexibility to say, well, we're not going to hold you to that minute. We can simply say, the officer acted in a reasonable way by keeping the discovery fresh before assessing, or actually they didn't.
I mean, I think that's a very interesting argument, but I suppose I would counter that one by saying, well, when the discovery rules were rewritten for self-assessment, that gave the government the opportunity, or revenue the opportunity, to deal with that explicitly, and they had felt the need to put it explicitly in the VAT legislation, so it was obviously a live issue, and they took the decision not to put it into the self-assessment legislation, and so therefore I'm not sure whether those two actually do complement each other, or in fact, you know, oppose each other.
And the way I would put it is, back in '94, when TMA was amended, they weren't thinking in the rewrite framework of putting different words in. There was a history of what discovery meant, and they just simply used the same wording. So yes, they could have modernized the wording, and if the tax law rewrite had moved on to the TMA, it's possible that they might have used more wording, although a lot of the wording in the, even under the rewrite, uses the old rules, and I could have seen a lot of resistance to abandoning the word discover. And I think, as you suggested, if even though the revenue won, you think it would be right for them to address this question through statutory change. And am I right in suggesting that you would actually like them to incorporate a similar test to that found in the VAT code?
I think that is the right direction of travel in terms of the current framework. I think that I can understand completely why it feels wrong that an inspector or an officer sees something, you know, the day after the inquiry time limit expires, and then, you know, 3 years minus a day later presses the button to raise it. So that doesn't feel right, and therefore one can say, yes, there ought to be a solution to that. But I would much prefer a solution which actually put that in some sort of framework, legislative framework. I mean, you'd still have issues around the edges, wouldn't you, just like you do in those VAT rules about what is the point at which the officer becomes aware, but at least you've got some signposts as opposed to drifting fairly aimlessly.
So are you suggesting that the best way forward would be a bright line test like there is in the VAT, or would you like the flexibility that the cases on staleness have tried to accommodate?
My preference would be for a bright line test. You know, I think the way that the VAT legislation works, you know, the longer you wait, the more onerous, the longer the officer waits, the more onerous the obligation, as it were.
Yes.
And you can see some framework around that. So I would be more attracted to that than something which just left the thing completely to the tribunals without any framework at all. Because, you know, what 1 day to 4 years is a very long period of time for somebody to make that decision. And I got the sense when the Staleness argument was running through the tribunals that it was a little bit of, you know, put a finger in the air and what is reasonable, what is not. And I don't know whether some of those people that were saying, well, actually, this time frame that the officer has operated in is okay, was actually a mechanism for them to say, well, actually, okay, I don't actually believe in staleness, but if I do force to by the upper courts, then this is the way I'll mark it, rather than an absolute belief that that was the right thing. I don't know. I'm not in the mind of the tribunals. But the case that really tipped the balance for me on this was that case of Murban, which was the investigation case where, you know, the taxpayer had admitted that he was at fault. You know, there were understatements. He'd clearly not cooperated at all with the inquiry. It was going on, and you know, ultimately the revenue issued assessments, and they were thrown out on the basis it was stale, because effectively, you know, in colloquial terms, the revenue had known this chap was a wrong 'un for a long time, and hadn't done anything about it in terms of, well, you know, they should have issued assessments early. But then we all know what happens if the revenue issue assessments before they properly examine the case, and are those assessments reasonable? And you've got, yeah. So I felt, well, hang on, if that's the way that the law is going to work, there is something not right, because I think as a matter of public policy, that decision, great for the taxpayer, I don't think that could be supported as a matter of public policy. And that was an example of a tribunal judge really getting hold of the concept of staleness and pushing it to a degree that, I don't know, maybe even you were surprised by.
I'll express no comment on
that.
Yeah. But I think one of the things that staleness has allowed, and it certainly more effectively than judicial review, is that it actually puts the focus on the revenue to act expeditiously. Because I know I have gone through cases where we thought the staleness argument was going to run. We thought that the revenue had sat on a discovery. And we were able, through the tribunal, to demand disclosure of the documentation that would show, yes, the penny dropped 3 years ago and they did nothing about it. Now, the problem with going down the judicial review route is that it's going to be a lot harder to prove that the revenue even knew at that earlier stage, even though you might strongly suspect they did. And even if the test as to where rational delay coincides with the way the tribunals have actually decided this so far, I feel that it would be difficult to prove that point. And you wouldn't be able to get disclosure sort of ahead of a judicial review with all the time limits for that. And the revenue would just simply say, it's for you to prove. There was a tactical and procedural advantage with this being part of the Section 29(1) argument, that it was for the revenue to prove, and therefore it was easier for the tribunal to say, you jolly well show us when you made that discovery. And as a result, going forward, it ought to put more pressure on officers to act professionally. And I don't mean that they're all a bunch of amateurs, but nevertheless, they have to realise that when they discover a taxpayer's underpaid tax, it's not just a job for them, but this could affect real people, real lives. And actually, there is, I would say, a public duty to convey this information at a relatively prompt stage. And the judicial review will, those judicial reviews will definitely occur at some stage, but I think they'll be harder to get on off the ground, and there'll be less incentive for the revenue to get their own assessing house in order.
Is there a difference between keeping a taxpayer informed and actually raising an assessment?
Absolutely.
And so therefore in a situation where, every 3 months or so the revenue said, we know you did this avoidance scheme, we haven't raised an inquiry in time, but we're looking at that, we're trying to pull all the threads together to understand whether or not it works, etc., etc.
Yes.
And if you nurse it along, and then eventually come to the point that they say, right, now I'm ready to assess. So is it the sort of almost that the revenue going completely cold and not telling taxpayers anything, rather than the actual act of assessment that's an issue?
I think it will depend on each individual case. The circumstances you came up with are very similar to what was happening in Patullo. The revenue said, we see you took part in this avoidance scheme, can we have a copy of the scheme documents? And there was a Section 20 request. We don't need to go into too much detail, but the revenue told the Court of Session they need a Section 20 notice because they couldn't assess without this information.
Yeah.
And the Court of Session said that must be fine and granted it, and then the case was going to go up to the Inner House. In the meantime, time limits were coming along.
Yeah.
And the Revenue suddenly realised, well, they hadn't got this information, but they needed to assess. So they assessed anyway.
Yeah.
And then the taxpayer lost on that as well.
Yeah.
Now, a more recent case, which I was doing, was the Tim Norton, which was all about car benefit for a guy who owns a showroom, car showroom. But that was a situation where the tribunal judge was Charles Hellier. And it was actually quite interesting to have Charles Hellier hearing that case because we were pushing the discovery point. Because Charles Hellier was the special commissioner in Corby Sturton. So he was the first judge to use the word stale.
Yeah.
He was also one of the judges in the upper tribunal in Tooth.
Yeah.
So the two leading authorities, or if you exclude Patillo, were based upon decisions of Charles Hellier. And I was saying, look, you've got to decide whether or not the Revenue had acted reasonably. But the officer conducting a PAY investigation had told the taxpayer, we think that there is a car benefit.
Yeah.
Let's discuss this.
Yeah.
And they were discussing it on and off for the next few months. And then just before the time limit, the officer had to press the button.
Yeah.
And the judge said that's a perfectly reasonable way of behaving. And I accepted that most of it was a reasonable way of behaving, but there was a long gap at one stage. And I was basing my whole staleness argument on that one gap, where I said, that's when it went stale. But I certainly don't think there's any great benefit for taxpayers if the officers press the button, assess, immediately. Either the quantum needs to be discussed, or there is actually a technical debate to be had. So I have no problem with notifying the taxpayer of the situation in a prompt and professional manner is an appropriate way forward. You don't need the formal discovery assessment at that stage. And that's when the assessment time limit comes. But as long as that discussion is happening, then the assessment is being kept fresh. So the discovery is being kept fresh.
I completely understand that. I suppose, I was in the Revenue a long time ago, and that sort of time limit review for time limits and all of that so ingrained. And I know when I joined the Revenue, there was a story which I think was true of a quite senior inspector in the Nottingham area who had been conducting a capital gains tax inquiry for 6 years, and then 6 years and a day later, the taxpayer wrote and say, we concede you're completely right, but you're out of time to assess. And that's sort of, whatever you do, the time limit is what, you have the power through the time limit. So, I don't know. I think what's interesting is perhaps where we go from here.
Yes.
On this, because I think as it's opened up all sorts of issues here, hasn't it, around what the relative responsibilities of the taxpayer and the Revenue are concerned. The one that really interests me is we're working towards a system of almost real time working in the tax system through MTD. Now, it will be a while yet, and it may not see, I may have been retired by then, but before too long, it will be that you are reporting to the Revenue every month, 3 months. In some jurisdictions, it's real time in terms of that, isn't it? And your question is, if we have a framework that's built on returns and assessments and time limits related to assessments, how is that all going to play into a world where we're in real time? And although we may have assessments, we won't necessarily have assessments. And that, the death of the tax return, as was predicted whenever it was 6 years ago now, that does happen. What sort of framework should we have around discovery for that? And I know the Revenue are looking at, a new TMA. I don't know how radical they're going to be in that, but it seems to me that they ought to be, and we really ought to assess, what now is that balance between the desire of the revenue, for understandable reasons, for people to be on top of their tax affairs in real time, and the ability of the revenue to say, but we can still go back. Because it would seem to me quite wrong that you just have we adopt a 4-year time limit, or just roll the 4-year time limit forward forever in a regime where taxpayers are not having the space. If you look back, 100 years ago, you were assessed on an average of 3 years. And then when I learned my tax, it was a PY basis. So by the time you got to actually looking at the transaction, it was already 2 or 3 years old. And then we into the CY basis, and we know the CY basis itself can give you quite a long gap. Moving there into a real-time basis, we need to shift quite a lot of other things to make that work as well. And I don't know how you do it, but I think it's important that it's on the agenda quite firmly. And then that ties in with what information you give to the revenue in order to protect against a discovery or whatever. And how will that work in an environment where you're just basically passing data directly to the revenue with perhaps little intervention? And I don't know, have you thought about those sorts of things much,
well,
Keith?
A bit. I think the first question that has to be addressed is the general pattern that we already have within the TMA being an inquiry period where it's open season, and then a series of time limits for discovery assessments. Is that something which one should maintain, or does one rewrite the whole system? And I'm reasonably content with the current framework of, you can't expect the revenue to open an inquiry within a week. There has to be a period, and a year seems as good as any, on the basis there's an annual commitment. But if we're doing more regular returns, there may be even shorter periods.
I'm not even sure there needs to be an annual commitment in quite the way that we're used to, in terms of sending your accounts in every year. There needs to be some form of dividing it up into years, because that's how the system operates. But well, I mean, I'm quite radical in these ways, but it's interesting. Let's assume that you still have an annual commitment.
Yes, or at least an annual calculation process. Because obviously one question which could arise is, it could become more like Social Security or national insurance, and a lot of it's done on a payment basis or monthly basis. But assuming there is an annual personal allowance and annual rates, etc., then I think there has to be a time limit based upon that year, even if it's a sweeping up thing, in the same way as you have annual accounting for VAT, that you do things month by month, but then there's a catch-up period. And I'm sure Neil Warren will correct my examples, but it's either that or the capital goods scheme, whatever it is. You have a system where you look back over the year.
Yes,
I have no problem with that. And then the question is the current open season for inquiry and then subsequent discovery time limits right? Or does one have possibly a longer inquiry window and then very limited right of discovery? Or does one abandon the inquiry concept altogether and just say the revenue has the right to discover? Or issue assessments on discovery?
I don't know the answer to that, but it's interesting. Even if you take the first premise, if you're reporting quarterly and you've done a transaction in Q1, which the revenue might want to look at and might think that you've underreported, should not the obligation to the revenue to do something be triggered by that time rather than the 12-month annual cycle? It's not obvious to me that it has to be that 12 months if you're looking at a transaction. Now, obviously not everything is transaction based, but if somebody had done an avoidance scheme in month 1, should that give the revenue a lot longer to inquire than if they'd done it in month 12? It may be obvious, it may not be obvious, but those are the sorts of things one starts to have to think about in a real-time tax.
It's not at all obvious, as far as I'm concerned, because let's say you make a stonking great loss in month 1, and it's only in month 12 that you make the gain, which is going to be relieved by the loss. You can understand that the revenue won't want to waste their time into investigating a random loss. But there was a case which I don't suppose you actually read. I don't know how many cases you do read, because you seem to read an awful lot. But a case called Whitlock, which was what I call a good old-fashioned back duty case, first-tier tribunal. Does this name ring a bell?
The name doesn't ring a bell, but I'm sure that I do read them all, so the facts will come.
It came out in the last month or so, and what happened in Mr. Whitlock is that he lost everything, and the revenue went back 6 years. But the tribunal noted that his 2012 tax return.
Oh, that's the one where there was the figure was 1,000 times too big or something.
Yes, exactly. Yes. He had turnover of £35,000 and a declared loss of £264,000. And the tribunal readily accepted the revenue's suggestion that it should have been 26,400. Sorry, not loss, expenses 26,400. Now I take the view that because the revenue failed to inquire into the 2012 return, they are saddled with the accepted position that there are £230,000 worth of losses going forward, which automatically gets set against profits of later years. So even though the tribunal upheld the view that profits had been understated in 2013, 2014, 2015, I think they would have got swept up, should have got swept up by these possibly erroneous losses that had not been inquired into in respect to that early year.
And you're going straight back into Ceylon and all those cases, aren't you, about losses? Ceylon alone, I can't remember which one of them at least was a loss case, wasn't there? Where I know that was, but
under self-assessment,
there
is the obligation. The return becomes final if it's not been inquired into. And there was also a case involving capital gains tax, I think it was in the 1980s, called Todd and Southeast Motors, where someone tried to run a similar argument about capital losses brought forward. And the tribunal, not the tribunal, commissioner, maybe the High Court, said, sounds like a very sensible argument, but there is no mechanism for inquiring, using modern terminology, into a loss until it gets used. But that is something which is very different from self-assessment, because there is in fact a mechanism for inquiring. So arguably, this tribunal in Whitlock made a mistake by just assuming it was a mistake and forgetting that there was finality of the tax return. Now, we're not really wanting to be discussing that case, but that does then chime in with your point about a loss in month 1 and a gain in month 12. Should the revenue investigate while things are fresh? And there, one argument is there's no point in the revenue incurring resources until they need to. On the other hand, why should the revenue wait? Because evidence becomes weaker and weaker as time goes on. And if there is a challenge, the taxpayer is entitled to have notice of that at the earliest stage, so they can then protect the evidence that does exist.
It's interesting. It brings to mind something that a predecessor of mine as ATT President, Trevor Johnson, once said. You probably remember Trevor.
I know Trevor,
saying, taxpayers ought to be given the right to tick a box on the tax return to say, to effect, please inquire into this tax return. And that would give them finality.
Mr. Tooth did that.
In a slightly different way, didn't he? But actually, there ought to be a box on the tax return to say, look, I want certainty. I understand that will mean you'll look at things, but that's absolutely fine. Let's just get on with it. And I can remember at the time, this is some time ago now, sort of head scratching around that. But actually, the more you think about it, it is an interesting thing, isn't it? That taxpayer that wants certainty and can have it.
But the first thing I would say is entitled to that certainty, subject to what caveat?
Yeah.
In other words, I think you and I would both say, well, as long as that there isn't discovery of old language fraud,
yeah,
then that's fine. But we would want to sort of carve out the revenue right to discover there's been fraud. Would you agree with that?
I would agree with that, yes.
Then there's the question as to whether or not carelessness should be.
Yeah.
And then could you not say that's probably what we have already? You're entitled to that certainty with or without an inquiry. And even if there is an inquiry, you're not protected if there is carelessness or deliberate understatement.
Yeah, I suppose it's the balance, isn't it, of if you've put your hands up and say, I've ticked the box on this return, look at it because I want certainty, then you're less exposed than you are at the moment, where the revenue could potentially decide to, or the revenue might make a discovery, and therefore you haven't got that certainty. Now, obviously, if you're a fraudster, that doesn't matter. But if you, I suppose it's all around what if you've done around a tax treatment that is controversial, or there's more than one view of it, isn't there? And but these again, I hope that when we come to actually looking at the future shape of the Taxes Management Act and the broader sense of what the tax administration system should look like, that some of this sort of thinking is on people's agenda, rather than just trying to spatchcock what we already have into an MTD system. I mean, because I don't feel that that's the right approach. This is the opportunity, and the revenue the government want to modernise, and I think you've got to embrace all of those. What is the balance between the rights of the revenue to assess tax, vis-a-vis the right of the taxpayer to have certainty in their affairs? Is that an equal balance? At the moment, it broadly is in terms of time limits. Is that right? There is an argument to say, well, the power of the state is such that it ought to be more circumscribed than the power of the individual. So if I made a mistake in my return 7 years ago, I can show it, I should still get the tax back. Whereas it's not fair that the revenue should be able to go back 7 years. Those sorts of issues, which are really big public policy issues.
The question I would ask you, and it's very much a chicken and egg, should the ideal tax system be devised and then the revenue staffed to ensure they can deal with it, or should the tax system be devised based upon likely HMRC resources?
Well, of course, it's neither one nor the other, is it? Somewhere in the middle. I don't want public expenditure to be higher than it needs to be. I think what I would say is that actually it's the tax system and the tax management designed against a background of the way that it's going to be administered, which is a mixture of humans and technology. And I think that well, you're one of the experts on this to see, how the assumptions in the Taxes Management Act just don't immediately flow through into a world where computers do things. And that's going to increase even more, isn't it? I wasn't expecting to say this, but I'm a great fan of the West Wing TV series. I don't know if you ever watched the West Wing. And there's a wonderful thing where right early on, the president is being a nerd and doing the tax return for his assistant Charlie, and they press the button and it's file the return, and then 5 minutes later, that's it, your return has been accepted, you're over. And you think, isn't that how the tax system should be? Not that, okay, well, we have to wait for a very long time. Now, of course, it could never be quite that, but that sense of certainty. When I left the revenue and joined the profession, it was only then that I realised how much power I had as an inspector, and it was, I was a relatively junior inspector. But when I, got those accounts coming across my desk on a Friday, and I had a clear 20 of them, and I chose one for an inquiry and the other 19 I ticked. The relief at the other side when the notice came back saying your accounts are agreed, that could be put down and in the file, and that power was something that I don't think I appreciated the revenue, and I wonder whether that still the revenue don't quite appreciate the power that they have to disrupt certainty, and the need for taxpayers is to know where they stand, and a tax system that was partly designed, at least with that, to balance the need of the revenue to catch people that are fiddling. That's where I'd like to really have some proper discussion of that.
My personal view is that I think a lot of junior officers don't quite realise the effect that their letters have on taxpayers, for good or for ill.
Yeah.
As to whether or not the senior echelons of the revenue realise quite how powerful the revenue is, I suspect they probably do. And there'll be cynics out there who suggest they actually abuse that knowledge of power. There is certainly a perception of an imbalance of power. All the obligations are on taxpayers. Taxpayers, as soon as they make a mistake, risk penalty. But officers make mistakes, delay things frequently perhaps, without anything other than a begrudging apology if you're lucky.
And you do that at the sharp end, don't you, in a way that I don't anymore. And I think that real sense, and I know that the taxpayers feel that very strongly. And I can see entirely why coming back to square one, while the staleness argument was something that was very attractive to taxpayers, and not just to get them off the hook, although clearly in some cases it was, but to say, look, this is just not right. This has been going on for a very long time. If there's tax to pay, then for goodness sake, let's just get on with it. You can understand that emotional reaction. And I suppose I come back to where I started from, is the Taxes Management Act the right place to manage that emotional reaction?
But couldn't you say, and no disrespect to Mr. Tooth, he entered into what we would now call an egregious avoidance scheme, which was blocked within weeks of him entering into it back in 2009. Therefore, the several £100,000 of tax he avoided, there is a moral argument. I'm not going to say one way or the other whether I accept it, but there is certainly a moral argument. He should pay the tax. Yet, through the TMA, the Supreme Court has said, oh, no, you don't. So one could say that there should be no equity about a tax. If you owe it, you owe it. But you and I have all grown up with the concept that there are time limits, there's a balance. The revenue has to act timelessly. But the staleness is only one element of it. But I don't think you could say to someone who's facing the loan charge, for example, that the tooth outcome is fair compared with what they're suffering. I think the tooth outcome is fair, leave aside the disagreement on whether staleness was correctly decided. But the point is, the Supreme Court recognised there are time limits in the tax code. They have to be abided by. And it doesn't matter how badly you've behaved, even if there had been fraud. Once 20 years come up, the taxpayer is off the hook. Yet the people suffering the loan charge, who most of them would say they have been missold a scheme, they're having those same TMA safeguards bypassed by a special statutory code. Now, the question is, do you, well, so I don't mean to put it on you in this way, but do you accept that under a fair and balanced tax system, there will be situations where a taxpayer doesn't end up paying what should have been paid, but equally a taxpayer might end up paying more than should have been paid, and that's just the beginning and end of it?
I don't think you could ever devise a tax system in which that didn't happen.
You could just take out all time limits.
Yeah, but that would still require revenue action. I mean, taking
yeah,
out.
no, obviously.
Yeah. But,
assuming revenue action.
Yes.
Do you think the first question then is, do you think time limits are part of a fair tax system, or because they allow cliff edges both ways, they are inherently unfair and should be removed?
I don't think I'd ever thought of it in those terms. Yeah, every cliff edge has unfairness, isn't it? But you've got to make the system work. And would you change? Would making the time limit a different time limit?
Yeah, it just moves it further along.
I always think of my old granddad, who had quite a lot of chickens and sold eggs, and he. I don't know, I mean, he's been dead for 60 years or whatever, but I imagine that not every penny of the receipts that he might have had for selling his eggs necessarily found its way into the government's coffers. You know, should there be a power now for the revenue to investigate that and trace the money and, you know, find that 5p of it is mine? It becomes something at some point where you've just got to give up, and you've just got to say, you just can't go there anymore now. I mean, 20 years, is 20 years a reasonable time? I suppose it strikes me as not obviously wrong. Obviously, when time limits were first, you know, when inflation was such a big issue, time limits were quite sensible, because, you know, I was learning my trade in, I suppose, the 80s, a period of enormous inflation. So if you did actually say, well, we can go back, you know, 30 years, but the time you got back 30 years, you know, you were only working, you know, Thrums Halfpenny, and that kept you for a week.
Plus £200,000 interest.
Yeah. So I don't know. I think that time limits is there have to be time limits. I can't imagine a tax system without time limits anywhere in the world. But
well, I completely agree with you on that. You know, time limits, statutory time limits, have been around in other fields since Elizabethan times. Yeah. And there was a comment, I think it was Lord Sumption, in the Supreme Court in about 2011, non-tax case. Yeah. But making it clear that you shouldn't deprecate time limit defences as unmeritorious. They are part of a balance. Yeah. So once you've got time limits, then it means that just simply because you can't say someone must pay tax because they have underpaid. There are other issues that come in, and it's all part of this nuanced balancing system that the statute has to accommodate.
So would you be in favour of more nuanced time limits, you know, which might be related to the severity of the conduct? We have that at the moment, but it's quite narrow, isn't it, in terms of 20 and 4? Obviously, you've got the offshore stuff now. You know, the 1 year, 2 year, or putting some statutory obligation on the revenue to deal with matters promptly. I don't know. I mean, I can't imagine that you would want too many more time limits. I mean, we used to have 3, didn't we? We used to have 4, 6, and 20 in the old days, as I was brought.
Well, before that, it was 6 and 20. Yeah. And in 2010, it got moved. I never quite knew why, but wasn't going to oppose it. Yeah. I still like the 4, 6, and 20. I'm comfortable with those periods. Yeah. Yeah. The question is, how are they exercised? And the interesting thing about the Tooth case, if we go back to that, is that the revenue had almost, when the Kosovo decision came out in November, December 2013, the revenue still had a few months in which they could have issued an assessment. Yes. And they would have won. No, actually, I'm not sure they would have won. I dealt with one case called Atherton, where the assessment did actually slip out before the end of the 6 years. Yeah. I'm actually of the view that the tribunal was wrong in that decision, but that's history. But the majority of those cases, that cohort of cases, the revenue left it until after the 5th of April 2014. And on precisely the same facts, had to then make an argument on deliberate conduct. One of the difficulties I had with the way the revenue behaved in Tooth is that they were more than happy to say Mr. Atherton had acted carelessly, Mr. Tooth had acted deliberately, and they weren't actually addressing, in my sense, honestly what had actually happened. They were just trying to fit their arguments around the statutory time limits that they had to overcome.
Yeah, I mean, I think you and I discussed Cotter some time ago, but that threw into sharp focus, didn't it? So many issues with the Taxes Management Act. And I suppose, one of the problems is that so much of this jurisprudence has come in relation to avoidance schemes, hasn't it? And therefore maybe made the revenue's arguments more attractive on public policy terms. Because, these people did avoidance schemes that failed and they should pay the consequences. And that undoubtedly has coloured perceptions about this. And again, in terms of when you're going forward as to what the rules ought to be, how should that be managed? But if you should Mr. Tooth, if you like, if you want to say get away with it because of time limits, I mean, he did a scheme that didn't work. Should it matter about whether it was deliberate or not? Should not all taxpayers who did that scheme in the same year suffer the same consequences?
And the difficulty with that is it certainly makes a good, I would say it makes a good debating point as a sixth former school debate. But how do you get Parliament fairly to decide which taxpayers do not get their statutory rights and which ones do? Now, obviously, the sixth form response will be, well, it's an avoidance case. But I think you and I both know that trying to define what is avoidance and what in particular is the avoidance that is unacceptable avoidance would be impossible to reach any consensus on.
But it's interesting, we have in DOTAS, don't we, the 20-year time limit for failure to put the DOTAS number on the return. And you might think that the revenue might want to say, okay, if you've done a DOTAS scheme or you've got a GAR scheme or whatever, then automatically, regardless of conduct, it can be assessed for the next 20 years.
I can certainly see that happening. I'm not sure I would say it was a good thing, for the simple reason that DOTAS is now, the definition and the bounds of DOTAS are the gift of the revenue, not the gift of Parliament. And DOTAS was there for a particular reason. It was to allow the revenue to have early warning of what was going on. And once you start piling too much on DOTAS, and I think the APN legislation is a perfect example, then you actually undermine the original purpose of the code.
I was at some of those early meetings with the revenue when DOTAS was being introduced. You were probably at some of them as well. And it is inconceivable that there would have been any sort of agreement with the profession to have the DOTAS rules that we have now. It's quite, from a government's point of view, quite a successful example of salami tactics.
Yes.
You just bring something in which is relatively innocuous and people could cope with. And then it expands and expands and expands. And I've just been doing finance bill commentary this week on some of the follower notices, not the promoter stuff. And you can builds and builds and builds and builds and builds, doesn't it? And it's where you get the balance for the taxpayer safeguards in all of that. But I just hope that we can have a grown-up discussion as a profession with the government about these sorts of things and creating the right building blocks for a Taxes Management Act system that will be fit for purpose for a generation or so. Because I mean, fundamentally, what we've got it goes back to the 70 Act, and the 70 Act goes back to the 64 Act, and some of those, you know, it's a very long time, isn't it, that those fundamentals have been looked at. And maybe in the end, we won't get anything too radical, and maybe, you know, those structures that have worked in the past broadly will be retained. And if that's the right decision, then that's fine. But I just do feel that there needs to be a proper standing back and looking at, you know, the powers of the state versus the rights of the individual. And there'll always be hard cases and things that don't go quite right. But it's designing as far as possible a system that minimises that.
There's a lot to think about. I certainly would like there to be a sensible, honest conversation about the way forward, and there to be sufficient time to ensure that the tax system of the future actually works when it's first enacted, rather is already out of date.
It's taken at least 20 years for some of the real problems in self-assessment to start emerging, hasn't it?
When I was at the Revenue, as you might remember, I was with the Rewrite Project. So this was the turn of the century. And I was told...
That very old key, the turn of the century. I still think of Queen Victoria when people say that, yes.
I still think of Nicholas Parsons,
yeah.
But just one word out. Sorry, the turn of the millennium then.
Yes, yeah.
And I remember one of my colleagues, who was a senior civil servant, said there'd been a delegation of Japanese tax officers to the Revenue. And the Japanese were asked, how long did it take for self-assessment to bed down? And the answer came back, about 4 to 5 years. And the Revenue thought, oh, that's good. 1996 it came in, it's now 2000. We're more or less there. And one of the guests explained, no, 45 years.
Oh, 4 to 5 years, yes, 45 years, yeah.
So it might be that we work on introducing a new tax code, which will last, let's say, a quarter of a century. Yeah. By the time that becomes obsolete itself, all the self-assessment cases would probably have been resolved.
What a cheerful prospect that is. I think it will outlive my life as editor-in-chief of taxation, but
possibly. You might be there for its 120th anniversary.
Yeah. Feels like
it. There's a lot of work to be done, and I'm sure you and I would both like to be involved in those kinds of discussions.
Yeah.
But in the meantime, I think we've left plenty of things to think about in the future. Thank you very much for joining me. Is there anything else you wish to add at this point, or?
No, other than it's a delight to talk about these things, and it's good to be able to stand back occasionally and just think about the broader terms, because we get so involved in the day-to-day stuff. And that's been fascinating, and maybe it won't be too long before we can actually meet in person again, Keith.
Yeah, I look forward to that. Otherwise, if you've got any other topics we can have another chat about, then I'll be more happy to spend some more time talking.
Yeah, okay.
Thank you very much, Andrew.
Thank you.
Thank you. Bye.